Good morning. This will be a video presentation on public international law. Since sovereign states need to uphold their international obligation of addressing global challenges, the relationship between international law and national law is very important in the sense that the agreements or treaties signed between parties can be actionable and enforceable within domestic jurisdiction. From the question, we know that even though different states enter into the same agreement regarding the issue of climate change, there is the distinct difference in the implementation of it. This is because different states have different systems of harmonizing international law and national law. There are two different theories regarding the relationship between international law and national law, which are monist and dualist. According to monism, international and national law are regarded as a single system of law, that even though without any domestic implementing legislation, the international law would automatically become part of the national legal system. It adheres to the principle of supremacy of international law. Therefore, if there is a conflict between two systems, international law will prevail. Other than that, under the dualist theory, international law and national law are two distinct legal systems that occur independently of each other. For international law to apply in the national sphere of the state, it must be transformed into national law by way of domestic legislation in order for the state to benefit from or rely on international law. This is adhere to the principle of supremacy of the state, that the international law will not automatically be applied in a state. When two systems conflict, each system applies its own law. In the application of international law at the national level, there are two doctrines to deal with that. One of the doctrines is the doctrine of incorporation. It regards international law as part of the national law, and it could be applied directly in the state. On the other hand, the doctrine of transformation, that a rule of international law needs to be incorporated in a statute or an act of parliament for it to become part of the national law. The different practices in different states contribute to the variation in compliance with the emission reduction targets of the pact among states. There are two issues to be discussed. Firstly, how the fundamental disparities between monist and dualist legal systems contribute to these difficulties in legal compliance. In the United Kingdom, legislative power, specifically in treaty making, was vested solely in the Parliament. Without any legislation made by the Parliament, a treaty would not automatically become part of the English law. Therefore, the British practice regarding the implementation of treaties was based on the doctrine of transformation. In the case of AG for Canada against AG for Ontario, Lord Akin decided that the treaty itself does not have a force of law. Legislative action for the performance of its obligation is required, as the making of a treaty is an executive act. Besides, in the case of International Teen Council case, Lord Templeman said that the courts of the United Kingdom have no power to enforce treaty rights and obligations in the behalf of a sovereign government or private individual. If a treaty was not incorporated into laws of the United Kingdom by an act of parliament, the courts would not have any power to enforce the rights and obligation of that treaty. I would then compare the British practice with the United States practice. In the United States, although there is a supremacy clause under Article 4, Clause 2 of the U.S. Constitution, that all the supreme laws of the land are bound by all the treaties made. In practice, the treaties are divided into two categories of self-executing treaties, which can operate directly in the United States, and non-self-executing treaties, which do require legislation for it to be enforceable. This is different from the British practice in the sense that the UK require more time for a treaty to take effect because parliamentary legislation for domestic enforcement is required, while the United States might have considerably faster compliance in some cases if the treaty can be considered as self-executing. In the case of Sei Fuji against State of California, it was held that in order for a treaty to be operative without the aid of implementing legislation and to have the force of an effect of a statute, it must appear that the farmers of the treaty intended to prescribe a rule that, standing alone, would be enforceable in the courts. However, this distinction may cause ambiguity and uncertainty about which treaties can be regarded as self-executing and thus can be enforced immediately. In addition, the United States Supreme Court seems to have ignored international law in the case of United States against Alvarez Marchange, where the forcible abduction of a Mexican national by United States government agents was allowed. This is contravened by a bilateral extradition treaty. Therefore, this clearly shows that different states will have different level of commitment. Even though a treaty has been ratified and incorporated into a state may still act away from it since there is no enforcement mechanism. When comparing the British practice and the Malaysian practice, the application of treaties before and after independence is the same as that of the British practice. However, in Malaysia, according to Article 76 of the Federal Constitution, the implementation of a treaty or agreement is limited to Article 76, Clause 2, when it relates to matters such as the matters of Islamic law or the custom of Malays. The government of any state concerned need to be consulted. This brings up a concern that if a state has any specific clause in its constitution that exerts some limitations to the implementation of treaties concerning an environmental issue, such as in this situation, a multilateral environmental agreement that addresses the issue of climate change, it will become harder for the state to enforce the treaty when there is a limitation clause that the parliament can choose to enforce a treaty to a certain extent. Additionally, some of the countries are practicing monist theory. In France, when a treaty is duly ratified and after publication, it prevails over acts of parliament. This is supported by Article 55 of the French Constitution. Similarly, in the Netherlands, as stated under Article 93 of the Constitution of the Kingdom of Netherlands, the provision of treaties will become binding after publication. Article 94 also provides that treaties which are binding on the Netherlands are supreme over every national law. However, the supremacy is conditional on the approval of the treaty by the Parliament as provided under Article 91. As a result, a fair balance could be achieved between the primary duty of the government to promote international legal order and Parliament's control over the way this duty is exercised. This also shows that even though in the monist system, the general rule is that the treaty would automatically incorporate into the national law, there might be also some limitations in the national law itself to control that supremacy. The second issue to be discussed is what are the possible legal and practical challenges that each system encounters in harmonizing domestic legislation with international commitments. For the monist system, the possible legal challenge is the potential conflicts between the constitutional norms and international commitments. As the doctrine of incorporation is applied, there is no checking mechanism to make sure that the international law is compatible with the national law before it is incorporated into it. Besides, the practical challenge that the monist system faces is the insufficiency of public awareness, for which the citizen might not even know that a treaty was incorporated into their national law, and thus there will be lack of implementation of treaty. For the dualist system, one of the possible legal challenges is the delays or failures in the transposing of international law into national law. The failure to do so would consequently increase the possibility of legal fragmentation between the national level and the international level, due to the increasing occurrence of legislative gaps between different states. On the other hand, The practical challenge faced by the dualist system is political barriers when the objectives of the treaty do not meet the political will. Generally, both systems have some similar legal and practical challenges. One of the legal challenges is the difference in the interpretation and compatibility of international law. Different states would have different cultural norms, histories, and level of adaptability to international commitments. Some countries with geographical location that might not be affected by natural disasters or environmental issues might not have much concern about the environmental agreement as compared to other countries. Thus, they might have a more flexible interpretation concerning the treaty. Besides, both treaties have no enforcement mechanism and there are no specific consequences or penalties that will be exerted on a state if there is less or even no implementation of that international commitment. Additionally, there are economic pressures. For instance, economic pressures are more obvious in a state that is focusing on industry threat to earn income. This is because some of the industry might need to stop for operation to comply with the emission reduction targets. The state might hesitate in doing so that it would affect the trade flow and the economy of their state. Next, I will provide some recommendations to improve consistent adherence to the agreement across the various legal systems. When it comes to monist system, I would suggest that the state mostly make treaties that are aligned with the constitutional norms to avoid any inconsistency with the national law and to avoid any confusion when implementing the treaty. Besides, an institution should be set up to check and record the engagement level of the state in international commitments. In addition, when there is an international law incorporated into national law, campaigns or publication on social media should be held to raise public awareness. Other than that, when it comes to dualist system, a set of systematic international law incorporation procedures and an institution to specifically deal with the incorporation processes could be set up. This is to avoid the complexity of the implementing and incorporating process, and thus reduce the time taken for international law to be effective at the national level. Besides, the institution could always connect and coordinate with the institution of other states to solve the legislative gaps between them. Additionally, an international body could be set up to make sure the interpretation of the treaty in different states did not have significant differences. Both systems also need to have an enforcement mechanism that could be some specific consequences faced by a state if there is no contribution to the international commitment after the ratification of a treaty. Besides, international bodies could give financial support and technical support to a particular state for capacity building when they are facing economic pressures. In all, although there are different legal and practical challenges encountered by different systems, there are several approaches such as setting up an enforcement mechanism and an international body to give financial and technical support to a state that could be used to minimize the difference in the application and implementation of an international law in a country. It is important to have a uniform implementation of international law to make sure that the global issues that require coordinated global efforts can be solved effectively. Here is the bibliography of the assessment. That's all for my presentation. Thank you.